Ready, start. Moreover, what we find particularly troubling is the complainant's conduct in directing Rajinder, the mediator, and accompanying independent witness to remain outside the appellant's office during the crucial half hour in which the alleged demand and acceptance occurred. This was contrary to the explicit instructions of the DSP. Rajender could consequently make no positive statement on whether the appellant demanded or accepted any bribe, and this gap is candidly admitted by the prosecution itself. Both the DSP and the inspector of ACB admit they did not question the complainant on this point, and till date, no explanation has ever been offered for keeping Rajinder out of the room. They also admit that they did not question any of the other office staff or visitors. We note that the other mediator Balaji was not examined by the prosecution at all. These circumstances are nowhere addressed by the High Court. Such omissions cannot be brushed aside lightly as they strike at the root of the prosecution version and cast serious doubt on whether demand and acceptance were proved beyond reasonable doubt. In contrast, the defense has consistently maintained that the alleged demand and acceptance of bribe never took place. According to the appellant, the complainant entered his office alone and during the appellant's brief absence placed the tainted amount in the left drawer of the table. Accordingly, when the trap party entered, the appellant immediately denied having received any money, and the phenolphthalein test on both hands yielded negative results. We opine that the High Court has placed undue weight on the fact that in his statement recorded on the spot, the appellant did not mention going to the bathroom between 5 p.m. and 5:30 p.m. and the same has clinching value as the evidence recorded at the double inverted comma earliest point of time double inverted comma close. We disagree. The post-trap report and several depositions themselves note that the appellant was perplexed and confused when the trap party burst into his chambers. If the defense version is believed and he first saw the money in the drawer only after it was opened in the course of the trap proceedings, it is more consistent that he would not have thought to refer to a routine detail such as a brief bathroom break at all. The circumstances on record support this version. As discussed above, the complainant did not take Rajinder into the chamber. Even in his version, the complainant acknowledges that he himself placed the money in the left hand drawer of the appellant's desk. Both the DWs support the defense version. DW1 explained that he had official reasons to visit the appellant's office on 25/9/1997 and again on 26/9/1997. On that day, around 5:15 p.m., he came to the appellant's office after finishing work at the neighboring Rangareddy labor office, and the attendant Abbas told him the appellant was in the bathroom. Importantly, DW1 states that pulling aside the curtain of the chamber, he saw the complainant sitting on the left side of the table with the appellant's chair vacant.